The top story, doctor-assisted suicide or euthanasia is now officially unlawful. This after the Supreme Court of Appeal overturned a High Court ruling that allowed a terminally ill cancer patient the right to commit suicide with a doctor's help. Government has won its appeal against a court order granting a terminally ill patient the right to die. In its arguments, government said that the right to die can be abused. According to them, the doctors had taken an oath to save lives, not to take lives.
Have been throughout alerting viewers, listeners and judges to Section 11 of the Bill of Rights contained in our Constitution. Section 11 of the Bill of Rights consists of 5 words. Everyone has the right to life. Now, the court that breaches in the first instance, that's the North Gauteng High Court, did not have the jurisdiction to find that euthanasia is acceptable in South Africa. The Constitution of the Republic of South Africa is a book, it is a law that is higher and it's binding on all our courts. Only the Constitutional Court can interpret it otherwise. The provisions in the Constitution is so clear. It says everyone has the right to life.
Now, joining us on the phone line to discuss this further is criminal attorney Mr. Marius du Toit. Good afternoon to you, sir, and thank you for joining us here on ANN7. First
thank you for having me.
What do you make out of the ruling by the Supreme Court of Appeal? It seems to be a big blow for pro-euthanasia activists.
It is, but I don't think it's the end of the line for them, though. I think, firstly, we must understand what the Supreme Court of Appeal said. They said in this instance that the person who brought the application had passed away before the matter was heard.
Yes.
And there was a specific order that this person sought before he died, that he could be assisted in his death. And that order, the court said, well, it serves no purpose for them to consider it, and hence the matter is a moot point. So that's the first thing. So we have to understand that when this matter came to them, because the applicant had already passed away, the whole purpose of the application has become superfluous. Secondly, the second thing that the court raised was, of course, the fact that they felt that it was not necessary and it was outside the ambit of the High Court's authority to go and expand on the definition of culpable homicide and murder. Remember that they are common law offences. What that means is that you will not find in a law book in South Africa the offence of murder or the offence of culpable homicide. It's something that has been generated over time, and it came from the ancestral laws, from the Roman Dutch law, and so on. That's where the concept came from. And as a result, they say you can only expand on that if there's a need to expand on the common law. And what they said is there's no need for it at this stage. And if there is such a need, lobbyists should take the matter to Parliament so that Parliament can enact it, so that they as courts can just interpret the legislation. But they felt there was a need in this instance to elaborate on the definition of murder and culpable homicide.
Marius, can we just further expand on some of the key arguments that were presented by the government to try and bolster their case?
Well, I heard I think it's Zahir Umar that was just speaking about the right of life, and that's, of course, the crux of it. I think they believe, on the one side, they say, well, you have a right to life, which means that you can't just unilaterally authorize a person to be killed. We have to remember that what is the definition of murder? Murder is the unlawful, intentional causing of the death of another person. So the moment I assist in your death, in other words, I am causing your death. I'm part and parcel of the person who is furthering your death, and hence I'm guilty of the definition of murder. So first and foremost, if I assist you, how terminally ill you may be, the moment I do so, I'm furthering a crime, and hence I'm guilty. So the only way you can authorize that is if the court says, well, listen, there's legislation that allows for it, and hence, because legislation allows for it, therefore we can do it. But there is no legislation that allows for it. So what they sought was they wanted the High Court to authorize that he could be assisted in his death by the doctor. Now, the High Court gave such an order, even though it might have been a legal order, even though the order was set aside by the Supreme Court of Appeal. The reality is there was such an order, and because there was such an order, the doctor who assisted in his death acted lawfully because there was an order authorizing him. So by the time this matter came to the SCA, of course, the whole scenario has changed. Now the person has passed. The doctor can't be charged for any offence because there's no knowledge of wrongfulness, because he was authorized to do what he did. Unlawfulness is therefore excluded. And because of that, you have a scenario where, the doctor can't be charged, the person is already passed, and hence the only thing that now needs to be considered is to whether the legislation needs to be enacted to change it. It's not the place of the court. That's the place of the legislator, which is Parliament.
Marius, thank you so much for your time this afternoon. We always appreciate chatting to you.
Thank
Marius
you.
du Toit, criminal attorney there, just chatting to us with regards to this landmark judgment. Let's continue the conversation this afternoon. We are now joined by medical expert Dr. Terence Komal, who also joins us on the phone line. Good afternoon to you, Doctor. Thank you for joining us here on ANN7. First and foremost, your reaction to the Supreme Court of Appeal now making euthanasia unlawful.
Yes, I strongly believe, and thank you for having me on your show. I think the important thing for me is to understand the specifics and dynamics of what the judgment was about. I think I'm a little, blindsided by the fact that we don't have the full judgment available for me to peruse and then further comment. But I'm quite convinced the court and some of the build-up to the argument with the specificities in this case of assisted suicide or euthanasia. I do believe that the right to life is still primarily the decision in question, something that the Constitutional Court will have to make a final definitive ruling. I'm of the opinion that in the process of what we currently offer, and I respect the opinions of our regulator like the HPCSA and the Department of Justice, that where do you draw the line? But then the question comes about is where do you draw the line on a lot of matters, specifically in terms of medical treatment? For example, a patient who is very terminally ill may legally consent to surgery that could be considered life-saving, knowing the risks are high, and that the National Health Act in Section 6, 7, and 8 authorize the patient to make an informed decision for the potential to survive. But then the decision of whether to live or not is then now precluded, and I'm of the personal view that may have to be reviewed. That is, again, if we look at the context of palliation and palliative care, a lot of patients in palliative environments are provided narcotics and opioid drugs, which are well known to cause sedation and pain relief, but also run the risk of lowering blood pressure and eventually causing a patient to pass away. What the initial application in my mind was to regulate what is being offered anyway. And there may be very strong opposing views to this, and this is just my perspective. Palliation involves making available lethal drugs in small doses. Most hospitals, or a fair large volume of hospitals, have access to automated pain pumps and systems that are fitted to patients who are in palliative states, where their main maintenance is to maintain life and improve their quality of life. The resulting risk is the patient may then strategically press a little extra, which could then result in the same issue of euthanasia. So it's a very fine line that we're trying to define, and obviously, we have to apply our minds a little bit more, seeing the judgment and seeing the context in which the court had ruled, because I'm quite convinced that the context is important to understand where the ruling came from. Again, I'm of the opinion the Constitutional Court may come to a different view, because I have seen different views from the judges so far in the discussion and build up to this judgment, and I'm not even sure if there was even a dissenting minority judgment. So again, from a medical perspective, in my personal opinion, I do believe what they were asking of the court was not unrealistic from the regulator side, but it has to be balanced with the right of what patients need. When you are at that stage in life and you need to make a decision, are you entitled to make that choice for yourself? In my view, you should be entitled. Obviously, the courts have ruled different, but the context of their judgment is vitally important. Rather than just extrapolating and saying the court said no, the question is what do they say no to what extent, and for what reason?
Doctor, I hear you when you say that, of your opinion, a patient should be given that right. But there's also been a lot of talk around that right being abused and whether, the right to die will be taken advantage of and people will abuse that right. What are your thoughts around those discussions?
I fully agree there's always going to be the risk, and that's challenging, especially in the medical fraternity. Where do you draw the line on risk? But the reality is, for example, if you go to a hospital and the requirements of the National Health Act in terms of Section 6, 7, and 8 oblige every healthcare practitioner on a simple operation to give you the option of the operation, all of the alternatives, every material and vague risk of an operation, and the alternatives. In reality, although it's legislated, it doesn't happen. So when you make a decision, and I can give you a classic case, a patient goes to hospital and the surgeon who now in private knows there may be a benefit says, Mum, if you don't do this operation, your child could die. The poor mother is not given a valid informed consent. She signs as if she has valid consent, but makes a decision on another agenda. That doesn't necessarily mean the law's been complied with, but it doesn't mean it doesn't happen. So all we're saying is the fact that you say there is the risk to abuse doesn't mean it should or should not be allowed. The same argument could be made for smoking, the same argument could be made for alcohol, the same argument could be made for weapons and ammunition. The question is, how do you manage the process? Because, excuse me, turning away from that process doesn't mean you're stopping it. Because every day in every other place that offers palliative care or oncology care, patients are given high doses of drugs to reduce pain. But there's the material risk every day that those doses may be too much or too little. And when it becomes too much, the patient could slip into a sleep and then pass away. That's not euthanasia. They call that palliation. But the principle is exactly the same.
Doctor, thank you very much for your time and for unpacking those details for us. Dr. Terence Komal, medical expert, just chatting to us here with regards to that landmark judgment that was made with regards to a person's right to die or euthanasia. Let's continue this conversation. We are joined now on the phone line by Incredible Happening Ministries Pastor Mboro, who joins us on the phone line. Good afternoon to you, Pastor. Your views and comments with regards to the Supreme Court appeal now officially making euthanasia or the right to assisted suicide, as it is also known, unlawful.
The challenge is that this thing, as the doctor, I just found him almost half there. It has a lot of issues inside and the facts and medical terms. For one to give proper, indication and suggestion, one needs to know fully about this. There is still a lot to be learned and understood because we are not in the medical field. And if someone is in terrible pain, a lot of things has happened. You find this person takes this tablet and that one and mixes everything, and they do overdose. And overdose, it ends up killing some. Some they survive because of the pain the person is feeling. Someone may even say, you know what, if this operation has to be done for me to live, I'd rather not do it. Let me die if I die. Some will say, no, I don't take any medication. I'm diabetic. I'm in that state, and they die. So it's really complex.
It is very, very complex. Pastor, I just want to get your personal view with regards and your personal feelings around, the topic of euthanasia. What are your thoughts?
As I answered, a person to be killed, when you say, like the Bible says, thou shalt not kill. You cannot kill anyone. But you see, the methods that are used in the medical field, some of them, people can die anyway. And it's hard for someone who is really in a terrible pain that they know the person is not going to recover at all. In this, the person is going to die anyway. And the person has to stay screaming. You look at the worst situation where the person is screaming and can even pray and say, God, please take my life, take my soul. This is too much. There is no cure for the situation. Now, it is how this thing is managed. I think for me at this stage, my point is thou shalt not kill. We abide by it because that's what God says. What God says, whether one likes it or not, we abide by it. And that's my stand. The final point I want to say is that this thing, because it's medical, I still need time to really look into this and really understand, because the way the doctor speaks, his opinions and the way he indicates these things, it makes sense. Now you need another one to hear, because I'm not in the medical field, and it depends who presents. And in this complex issue, I think the debate needs to continue. We need more information. That's
We
my
hear
point.
you. We hear you. Thank you
We
very
need
much,
more.
Pastor, for your time this afternoon. Pastor Mboro there just giving us his view with regards to doctor-assisted suicide or euthanasia now being officially declared unlawful. This after the Supreme Court of Appeal overturned a High Court ruling that allowed a terminally ill cancer patient the right to commit suicide with a doctor's help. Stay tuned to ANN7. We are going to continue in-depth discussions around this topic.